yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning again. We are truly delighted to hold our oral arguments here in historic Johnston County. I'm very thankful and excited about the fact that you all have been such gracious hosts and allowed us to be here today. The court calls Vizant Technologies versus YRC Worldwide Incorporated. Ms. Lincoln.
Chief Justice Beasley, and may it please the court, my name is Sara Lincoln, and along with Susanna Hicks, we represent Vizant Technologies, the appellant in this matter. I would like to reserve 7 minutes at the conclusion of my argument this morning. This is a breach of contract case. Enforcement of contracts as written protects the expectations of the parties to those agreements and brings reliability to our marketplaces. When contracts are thoroughly negotiated between sophisticated business parties, every effort should be made to enforce those contracts as written. Both the law and the business policy of the state of North Carolina favor the enforcement of contracts as written. This court has the opportunity, with a de novo review of the matters from below, to reverse the trial court's decision in this case and to enforce the contract between Vizant Technologies and YRC Worldwide Trucking as written. 3 reasons why this court should take those steps today. First of all, the trial court's interpretation of the written contract between Vizant and YRC Worldwide Trucking isolated 2 terms within that agreement in an incorrect application of black-letter law, which prohibits a trial court from isolating provisions in a contract and rather requires the trial court to consider the contract in its entirety. 2, even if this court were to agree with the trial court's decision in this case, those issues are issues that should have been submitted to a jury for a trial. And finally, Vizant's damages, as discussed in the trial court's opinions, were the fee that it was entitled to under the terms of the professional services agreement, which is the contract between the parties in this case. Those fees are outlined, and the manner in which those fees are to be calculated are outlined precisely in the agreement between the parties. And when reading that contract as a whole, it requires the court to apply the formula as outlined in the written agreement between the parties. As you know, the standard in a summary judgment case, when being reviewed de novo, is to review the contract in its entirety. And I would like to start by outlining what the undisputed facts are surrounding this contract.
Before you
Yes,
do that,
Justice Hudson.
I want to ask you about the interlocutory nature of this order.
Yes,
The order on appeal here is an interlocutory order.
Yes,
That's been addressed in your brief a little bit, but I'm a little unclear as to how, what your contention is that it affects a substantial right and should therefore be reviewed at this point, because there's still claims to be tried that remain in trial court.
Yes, so we understand that it is interlocutory in nature. The substantial right that is affected in this particular case is the fact that Vizant would be subject to 2 trials with overlapping factual issues. The 2 terms that the trial court isolated down below were as a result of and identified. Both of those terms appear in the same paragraph in the professional services agreement. Therefore, if there was a change in the decision, if you all were to agree with us and reverse the trial court, the as a result of language implicates the identified language in paragraph 6 of the professional services agreement, which appears at page 13 of the record.
Well, the fact that there could be 2 trials, as I understand the law, the substantial right is affected if there might be the risk of inconsistent verdicts, and I'm not quite sure I see how that could happen here, because if you had one, facts were determined, then they would be law of the case, so there wouldn't be an inconsistent.
Well, it is possible that a jury, in interpreting, if the determination is that the contract is ambiguous, and the jury goes back and reviews the contract as a whole, as it should, then it is possible that a jury in a first trial, considering only the issue of whether or not the term identify is ambiguous, could go back and determine in a later trial, if the trial court is reversed, that the term as a result of makes the term identify ambiguous and you are at risk of inconsistent verdicts on the interpretation of that phrase within the contract.
But if one jury determined the meaning of that, the ambiguity, wouldn't that then be law of the case in any subsequent trial of the same case on a different claim?
Well, it would be nice to believe that it would be the law of the case. It still could potentially subject us to inconsistent verdicts even beyond just those particular phrases. You're still going to be having a jury that is evaluating any number of the clauses within this contract that could be interpreted differently. So again, and I started doing exactly what I said the trial court shouldn't have done, which is to focus on one thing within this contract, which we're not supposed to do. And I think that the risk is that if they're looking at the contract as a whole, there may be other provisions within the contract that a jury could interpret differently in a second trial, resulting in inconsistent verdicts.
The only two that you want to specifically point to are the ones, the provisions that you mentioned in your answer to Justice Hudson.
I'm sorry, Justice Ervin, I missed the first part of your question.
I mean, you identified a couple of provisions that you were concerned about inconsistent interpretations of in your answer to Justice Hudson. Are those the only two specific concerns that you can point us to at this time?
I do not personally have a concern about those two provisions because I believe when the contract read as a whole is clear and unambiguous, Your Honor.
I'm trying not to get into the contract interpretation issue. At this point, Justice Hudson's question had to do with whether the case even should be here in the first place. And so obviously jurisdiction is something we have to confront before we confront anything else. You gave two specific examples of contract provisions that you thought might be subject to inconsistent interpretations by way of a jury verdict. Can you give any other specific two, or is your contention that the case is properly before the court? Does it rest on your concerns about the interpretation of those two specific contractual provisions?
Yes, Your Honor.
Is that clear? I'm sorry, I wasn't clear earlier.
No, you were clear. I just didn't hear the first couple words from your question. No, my reason for focusing on those two particular terms were because those were the two terms that the trial court focused on, not because we had specific concerns just about those two terms. I believe that the contract, when read as a whole, is clear and unambiguous. That does not mean that a jury would necessarily agree with me and think that all of the terms within the contract are clear and unambiguous.
Well, you and Judge Bledsoe seem to have had some disagreement over that subject yourself.
We certainly do, Your Honor.
Ms. Lincoln, it seems as if your notice of appeal did not include reference to the Business Court's first order, the June 26, 18 order. Can we assume that that's not the subject or in part of your appeal?
Your Honor, we did not reference the June 26th decision because it was a denial of a motion for summary judgment. By law, denial of a motion for summary judgment in this state is interlocutory, and there is no substantial right that is affected by case law. That's been the determination of this court for many years. I do not think that that precludes this court from reaching back and looking at the June 26th summary judgment order, in large part because of the way that Judge Bledsoe handled the two opinions. I think we would be in a different position if he did not write his second summary judgment opinion the way that he did. And he effectively reached back in his second summary judgment opinion and incorporated portions of that opinion into the second summary judgment order. And therefore, I think this court can, in its discretion, if it deems it necessary, reach back and consider whether or not Judge Bledsoe's first summary judgment decision was appropriate. And frankly, your role on a de novo review of a grant of summary judgment is to review the contract as a whole. And it's possible that in doing that, you would disagree with Judge Bledsoe's decision in the first summary judgment order, and in your discretion could reach back and address that.
But your primary argument today is that the second order awarding summary judgment on the ACH damages was incorrect.
That's correct, Your Honor. That is our primary argument today.
It seemed to me that the summary judgment aspect ended on page 19 of the first order, but then there's the motion to strike, which you could have brought before us, but you haven't.
That's correct, Your Honor. As an evidentiary matter, we don't necessarily disagree with Judge Bledsoe's motion to strike. I think in terms of application in front of a jury, what he was ruling in that particular instance was that the ultimate opinion from Mr. Emanuel could not be presented. However, he did not exclude evidence of what is in the contract, and what is in the contract is the formula. And the formula could still be presented as evidence and does not necessitate expert testimony.
But you would still be required, though, to elicit evidence from which a jury could find damages in accordance with what you describe as the formula.
Yes,
right?
sir, and we believe we've presented that evidence. If you look at
Well, and let me make, I was a history major and am not a mathematician, and so bear with me a second, but at least my understanding of when you say the formula, you're referring to a calculation that would essentially compare the overall cost of credit card transactions for YEC at one time as compared to another, and therefore damages would be calculated by taking those two aggregate differences and multiplying it by the factors specified in the contract?
That's correct, Your Honor.
So it does not matter why a change in the overall level of credit card cost would occur under your interpretation of the contract?
That is our interpretation of the contract, yes, Your Honor.
Well, just to get directly to the nub of the matter, the second term in the formula, at least as you use that term, is post-agreement financial payment cost, right?
Yes, sir.
All right, again, I'm asking them one at a time because I want to make sure I'm not wandering off in error before we even start. That provision defines post-agreement financial payment cost as, quote, the financial payment cost that client incurs on a monthly basis as a result of the strategies and solutions that have been identified and recommended by your client. I mean, that's the second term in the formula.
That is the second term, yes,
As
sir.
I understood Judge Bledsoe's order, his interpretation was that the words "as a result" required you to prove that the reductions in credit card costs stemmed from recommendations that you made, and I'm not wanting to get into whether that means separate and apart from things they were already doing or not. But do you deny that that's the correct interpretation of that contract, that that's what "as a result" means?
I deny that based upon the reading of the contract as a whole, and
Well,
I would...
What other parts of the contract?
Yes, sir.
Because, I mean, just as a matter of ordinary English, it seems to me that looking at that language as it's written, "as a result," would tend to suggest that there's a requirement for a causal nexus between the change in the level of credit card costs before and after.
Yes, sir. Well, what I would point to are a number of the provisions. First of all, paragraph 13 outlines the client data and information obligations of YRC Worldwide Trucking. That is the information that they are required to provide to us in order for us to calculate both the post-agreement financial payment costs and the pre-agreement financial payment costs. That is the body of data that is required for Vizant to analyze under the terms of this contract. If that data, as provided in accordance with the terms of the contract, does not specify, and in this particular instance we have evidence that YRC in fact did not have the ability to specify which customers individually were switching from credit card to ACH in a comprehensive way. They had some information on that, but not a comprehensive set of data on that. This is the data point that we are working from under the terms of the contract. In addition to that, if you look at paragraph 8 of the contract, which is on the record at page 14, we get paid, there's a phrase in paragraph 8, notwithstanding anything to the contrary in this agreement, any financial payment cost reductions that are realized by the client after execution of this agreement, but prior to the issuance of the report. shall also be considered financial payment cost reductions as if specifically identified by Vizant. They shall be subject to the professional services fee listed herein for the year 1 fee rate. Again, this means that if they engaged in, for example, a shift of clients from credit card to ACH, which would result in cost savings, in the period of time after the contract was signed, but before we made our recommendations, we are entitled to a fee for those savings, which is not as a result of any recommendation that we made, but because that's how our contract reads. In addition to that phrase, I would direct you to paragraph 24, the termination clause within the contract, which again outlines how Vizant is to be paid even if the contract is terminated, because they've provided an idea to the client, then they get paid for the savings. If you read paragraph 24, there is no reference to as a result of in paragraph 24.
But in both paragraph 8 and in paragraph 24, there is a specific reference to, in all caps, not all caps, but in capital, starting with capital letters, financial payment cost reductions, which in ordinary contract drafting, as I understand it, would refer me back to the way that that term is defined in the definitional section of the contract. So your contention is that even though that defined term is used in the definitional, used in these two provisions, is defined in the definitional section as including only things that are as a result of, that this other language essentially means that as a result of doesn't mean anything?
That is essentially...
Is that essentially your argument?
Yes, that is essentially correct, but in large part also because it's modified or enhanced by the data that the client is required to provide to us.
And your theory there is we wouldn't require data if we didn't...
if it didn't show
it wasn't completely consistent with the damage, the fee calculation provision, there'd be no need for it to be broader than that?
That's correct, Your Honor. That because the data that they provide us under the terms of the contract is all we have to work from in order to calculate our fee.
But bottom line is, if we agree with you, you would be entitled to the relief that you requested on appeal, at least if we get to the substance of it. If we didn't, you wouldn't be?
I'm sorry, could you restate that one more time?
I probably can't do it that badly, but let me try it again. Assuming that we were to agree with you as to the discussion that you and I have just had, you would be entitled to prevail.
We would be entitled,
Here.
at a minimum, Your Honor, in this instance, to present that information to a jury and allow a jury to decide that issue, at a minimum.
And if we did not agree with that, you would not be entitled to prevail.
That is how I would interpret
Okay,
Judge.
so you and I have at least identified what the crux of the issue, the substantive issue that's before us today is in the last few minutes.
Correct. So if you were to agree with Judge Bledsoe's interpretation of that phrase in the contract, then that's correct. I mean, we wouldn't be here if he hadn't ruled that way, Your Honor.
Let me just ask you for one point of clarification. In response to Justice Ervin, you said that at a minimum you would be able to present evidence to the jury about that point. Can you succinctly state what that point is that you would be able to present evidence to the jury on?
So if the decision is that as a result of is somehow ambiguous, then that issue goes to the jury. If as a result of is not ambiguous and you determine that the contract is clear on this point when read as a whole, that Vizant is entitled to calculate its fee as outlined in this agreement read as a whole, then we would be entitled to recover those sums of money.
It sounds like you're saying as well that as a natural outgrowth of this, then, that based on the data that you were given, which you say was somewhat incomplete from the other side, that every dollar of reduced credit card cost that was experienced by the defendant would therefore be attributable to your client's strategy to help them to save funds. Are you saying that every dollar that was saved therefore is attributable to your your fee?
Your Honor, you have to make that assumption under the terms of the way that this contract is written. Yes, I think the contract assumes that, and that when you read the contract as a whole, it is clear that that's what the contract assumes. And the reason for that is it would be impossible, it would be unworkable under this agreement for us to be able to assess each and every customer and why they made a switch. They may have made a switch because they just decided that they didn't want to have credit cards anymore. It would be impossible for us to go to, particularly with a company the size of YRC Worldwide Trucking that has thousands and thousands and thousands of customers, to make that assessment on a customer-by-customer basis. Because this is Vizant's work, this is what they do, they know that companies do not track that kind of data. It would be impossible to figure it out. So they have made a determination of the type of data that they can use to make those assessments, and that's what they ask their clients for, and that's why the data is specifically outlined in the contract.
How do you respond to what they've raised in their brief, which is that with that very direct strategy that your client employs, it does not take into account then aspects of other factors such as their losses that they had in recent years, the fact that you've got market factors that come into play. Doesn't that go towards the lack of the trial court's confidence in the calculation of damages if you're not taking into account those other extraneous market factors and other aspects?
I don't think it does, and the reason for that is that the formula is outlined in the agreement between the parties. If YRC had wanted a different formula, this was a thoroughly negotiated agreement between sophisticated business parties. It is undisputed that there were lawyers on both sides of this deal. If they didn't like the way that this fee was going to be calculated, then they should have changed the manner of calculation. They could have at any time said, we're going to provide you with a different data set. We're not going to just provide you with these general numbers. But if you look at paragraph 13 in the agreement, it very clearly lays out the data from which we are to calculate our fee. And that's how our fee would have been calculated if this contract had gone forward between the parties and had not been terminated. It would not have been subject to an evidentiary evaluation. It would not have been subjected to the issue of market factors. It would have been calculated exactly as outlined in this agreement.
So I want to make sure I understand your interpretation of the agreement and how the fee is calculated. And are you saying that if the financial payments cost goes down because their overall volume of business goes down, that you still get your fee?
So it depends on how you look at the data. So if there is a substantial drop in credit card usage, one would anticipate a corresponding drop in ACH usage. So what we're really looking at is the difference between those two deltas. So if their business is going down, it's going to go down in both of those areas. So it does, to some extent, account for market change. It may not be specific, but it does, because of the way that this fee gets calculated under the agreement. That is something that comes into the calculation, even if it isn't specific.
Well, and I would then ask, is the reverse true? So if they had experienced a huge increase in the volume of their business, presumably the overall total of their financial payment costs would go up. And would you then not get a fee at all?
That's correct. So there is balance there that's built into the formula that lasts over a period of 3 years.
How is it that the formula is worthy of the precision that you claim in light of the fact that not only did YRC not see the formula as being workable here, but even the trial court felt as though it did not have the reliability because of the speculation that was attributed to the experts' determinations by the trial court?
I think that the trial court focused on an evidentiary standard for the formula, as opposed to recognizing that it was a formula that was a negotiated agreement between the parties. And this is how this formula was going to be applied if the parties move forward. It's how that formula gets applied in every agreement that Vizant has, unless the party that they contract with negotiate something different with them.
But even factually, if the formula is determined by way of what you're saying was an arm's length negotiation between the parties, if that is to be translated through the evidence to what the damages would be, assuming that your client would be eligible for damages, even if the formula is known through the evidence, if the damages cannot be accurately calculated, then how is it that the damages are going to be such that they are deemed to be reliable by the trial court that has to determine that before it would go to a jury?
They can be accurately calculated by utilizing the formula in the contract. The issue of whether or not the calculation is accurate, as it's been addressed by the trial court, has been based upon an evidentiary standard as opposed to reading the contract and applying the formula as written in the contract. And I believe I'm down to 5 minutes, so I'm going to reserve the rest of my time. Thank you.
Mr. Stroh. Stroh.
Thank you, Mr. Stroh. May it please the court, good morning. Consistent with the position that Vizant advocated for the first two-thirds of this litigation, the trial court held that unambiguous language in the contract limited Vizant's fee to a percentage of cost savings realized as a result of strategies that Vizant identified and recommended. YRC then showed that Vizant could not produce evidence proving the amount of fee saved on account of, as a result of, Vizant's recommendations. That carried YRC's initial summary judgment burden of showing that Vizant could not prove an essential element of its case because under Kansas law, which controls proof of damages, is an essential element of a breach of contract case, as Vizant admits in its opening brief, page 8, note 1. Because YRC carried its initial burden, the burden, of course, shifted to Vizant to come forward with evidence showing the amount of fees avoided, the amount of cost savings realized as a result of their ideas, their strategies, their recommendations. Vizant offered nothing. And because of that, under a well-established Supreme Court jurisprudence, the trial court was obligated at that point to grant summary judgment. And it is quite notable, I think, that Vizant makes no effort to argue that it actually came forward with evidence showing the amount of savings realized as a result.
Before you get too far into that, I'm sorry.
No, please go ahead.
Before you get too far into that,
Yes.
do you have any response or anything to say about the jurisdictional aspect of the interlocutory appeal and whether
Sure.
It affects a substantial right?
Yeah, I find myself in a relatively unique position of feeling compelled to state why I think I was wrong below when I argued to the trial court that there was no substantial right, and that after then reading the trial court's opinion, saying I was wrong, I agreed with Judge Bledsoe. And so as much as an appellee would like to say, kick him out of here, there's no jurisdiction, I think I'm obligated to tell you why I think Judge Bledsoe was right. And that is because in just one instance, the word identified, the court deemed to be ambiguous, subject to these two interpretations. One being, did Vizant have to bring us new ideas, identify new ideas that cause us to change our behavior, or could they just parrot what they already knew we were doing and then claim a right to a fee? You don't know how the jury is going to answer that question in either.
Why does that matter for purposes of substantial right? At least if I understood my discussion with Ms. Lincoln, she indicated that essentially the question before us today substantively was, did the literal meaning of as a result get changed or modified as a result of certain other provisions, none of which, at least if I read them correctly, contain the word identified. So why does the fact that there might be a dispute over identified have anything to do with whether there's a substantial right in this case?
Because of the risk of inconsistent verdicts. So if the case, this appeal did not go forward and we went back to the trial court, we would have a trial on whether or not the other recommendation Vizant contends we saved money with, YRC saved money with. If that was the only issue before trial, whether there's a breach there, it is undisputed that YRC implemented that cost-saving measure a month before Vizant ever delivered its ideas. Vizant's position at that trial would be, it doesn't matter whether or not YRC knew it already. We identified it. We guessed what they were already doing, and we get paid for that, right? I would argue that identified can't mean that, because that'd be a pretty ridiculous way to go about doing business. Tell me what I already know, and I'll give you 30% of what my own efforts produce, right? So I'd be taking a contrary position. But we don't know, based on a jury's verdict, how the jury would resolve that issue. Even if we were to give special interrogatory to the jury, which I thought about, right? There may be more nuanced meanings to the word identified than the one Ms. Lincoln's advocating and the one I'm advocating.
And so, as the trial court looks at that term, though, and has deemed it to be ambiguous, then if it can be taken, and the trial court expressly found this, that it could be interpreted in the way that Vizant wants it, it can be interpreted in the way that YRC wants it, why wouldn't that be a jury question then to resolve the ambiguity in terms of what it means in the course of the contract?
Oh, I think that it is a jury question on that one limited element of the case, right? But it is absolutely not a jury question whether or not the contract requires a showing that cost savings were realized as a result of Vizant's ideas before Vizant gets 30% of them.
Well, I'm not sure that I follow how that gets you to the risk of inconsistent verdicts, because if the jury has decided that issue, why isn't it law of the case if there were a subsequent trial?
Because I don't know that we would know how the jury resolved the issue. We're going to present, was there a breach of contract? Yes or no? If so, damages, right? Not how did you interpret the word identified? And you could have one jury interpret it one way and another interpret it another way. That is why I think Judge Bledsoe was right that there is a risk of inconsistent
Well, I guess
verdict.
if a jury has already interpreted that word, why wouldn't the subsequent jury be bound by that determination?
Because I don't think we know how the jury interprets the word, right? Even if we were to go with special interrogatories and say, here's what Vizant says this word means, here's what YRC says that word means, do you find it to mean that? There could be still further meanings of the word identify.
But couldn't the trial court just say, jury's already decided that, move on, we're not giving that back to the jury? It's law of the case.
But we don't know how the jury resolves that one ambiguity, whether the jury resolves what identified means in the way that I've argued, or in the way that Ms. Lincoln argued, or in some third way, right? And then you could end up in a retrial, right? If we then come back to you and then there's a successful appeal, you could end up with a second jury interpreting that differently than the first.
Okay.
So I think that, especially based on Justice Irvin's questions to counsel, I think that the court is fairly clear on what the one and only formula in the contract is, and that is you take the pre-contract costs, subtract the post-contract costs realized as a result of Vizant's recommendations, and then multiply by 30%. That's how you get a fee. That's the only formula. And it requires a showing that savings were realized as a result of. And not only, as Justice Irvin pointed out, Vizant tries to argue that paragraph 8 and paragraph 24 somehow entitle them to get 30% of any transactional costs avoided because we lost hundreds of millions of dollars of business, right? Not only does the language in those paragraphs that say you got to go back to the definition of financial payment cost reductions, which takes you to paragraph 6 of the contract, which contains the as a result of language.
If you look, though, at the other paragraph that Ms. Lincoln directed my attention to when I was
13.
engaged in an amateur exercise in mathematics,
Right.
Which was paragraph 13, I don't see that term in paragraph 13.
Correct. What paragraph 13
And I
is...
think if I understood her argument, and she's got 5 minutes left to correct me if I misunderstood it, she's saying in effect that there would be no point in requiring the presentation or delivery of all of this broadly stated data described in paragraph 13 in the event that a calculation of the type that you're calling for needed to be made.
Ms. Lincoln misconstrues paragraph 13 in a very serious way.
Well, and I figured you were going to tell me that, so tell me more
Okay.
specifically how
So-
she misconstrued it.
The entire point of Vizant's services is that we are going to take your financial data, we are going to analyze it, and we're going to identify cost savings measures. Right? Paragraph 13 is simply saying, so that we can do our work and analyze your data, you must provide, YRC, you must provide your data to us. And if we're going to have an ongoing relationship, which is potentially provided for in the contract, you need to continue to provide your data to us on a monthly basis so we can continue to look for new cost savings ideas.
But if that were true, why would paragraph 24 require you to continue to provide the data under section 13 once you had terminated the contract?
Because the contract provides that they get savings over the course of 3 years, right? So if their ideas produce savings, as a result of their ideas, savings, they get it going forward 3 years. And so we have to continue to provide the data so that they could do their homework and calculate, here's how much our idea saved you.
So the data in paragraph 13 is the data that they use to calculate what their fee should be.
Right, but that does not, because they provide a wheelbarrow full of data of all types, does not mean they get all cost savings, a percentage of all cost savings in that wheelbarrow. They only get those savings in the wheelbarrow that their ideas caused as a result of their ideas.
And what's your response to their argument that there's just actually no way they could prove exactly which of your customers switched for which reasons?
Yeah, it's twofold argument. First, I'm going to address precisely that question, and then I'm going to explain how even if Vizant was right and it got 30% of all reductions in transaction costs because we lost hundreds of millions of dollars in business, they still don't have the evidence that they need to get to a jury on the damages issue. And it is unmistakably correct. That is it, and it has to do with the discount rate. But back to your question. And I forgot your question.
Your response to their argument that they actually can't prove
Yes.
what you're saying they need to prove.
Thank you, Your Honor. So Vizant made a strategic decision in this case. All right? Vizant advocated from day one forward, the contract requires a showing as a result of. That's the only fee we get. And then YRC produced data in discovery which showed a massive tens and tens of millions of dollars in drop in credit card payments received over the course of a couple years. Vizant decided at that point, we're going to try to claim that entire tens and tens of millions of dollars in drop in credit card payments received was as a result of our recommendation. And in fact, hired an expert who made those very statements. This is all as a result of, right? He'd been thrown out, of course. But because Vizant chose that path, Vizant never did the third-party discovery that it could have done to find out these damages.
So because I was going to ask you the same question Justice Earls asked you. How would you make such a calculation,
Sure.
In your view, assuming you're contending that it is not an unreasonable thing to try to undertake. What would you have to do in order to make the type of calculation you contend ought to be made?
You would need to do something which is frankly very simple. You would need to take...
Well, don't assume I understand it.
You would need to take the list of customers that YRC provided in discovery as their biggest credit card payers, right? And you would then compare that to, are they still, the data showing, are they still paying by credit card or not? You then go take third-party discovery of their payments department and say, did you stop paying because YRC, by credit card, they're still paying, but you start paying by ACH because YRC urged you to do, or because of something different. That's all you have to do, plus one thing, and it gets to my second point about why, even if you entertain their position that we get 30% of all transaction costs avoided because you lost hundreds of millions of dollars in business, you need, in addition to knowing you moved this transaction to ACH, and you did so because YRC asked you to switch to ACH, you also need to know the discount rate that would have applied had the payment been made by credit card instead of ACH. And discount rate isn't, I try to explain it in the brief, it's not something that I think we generally think of, at least in our profession. But what it is if I make a $100 purchase from a sporting goods store, and there is a 3% credit card fee for the bank and the credit card transaction company and the processor, the credit card transaction processors and the bank retain $3, and the store only gets $97. That, if you avoid making a credit card, somebody paying you with credit card, you avoid that discount rate. You get the full $100. But what you need to know is what is the actual fee avoided. Vizant's fee, if any, is based not on volume of sales that drop. It is based on savings achieved, transaction costs avoided. Not total sales, but transaction costs. So say you have $50 million in loss of credit card sales, right? And even if we say it doesn't matter that that happened when YRC lost hundreds of millions of dollars of business, they could still get a percentage of it, right? But it's not the 50 million in lost sales that they get 30% of. It is 30% of the fee avoided. That 3% that the sporting goods store didn't get, it's what fee would have applied on that 50 million, right? And because Vizant didn't do any work to identify what credit cards would have been used, we have no idea. And as I lay out in the brief, and as the evidence shows in the record, YRC had that discount rate, that fee, as low as 0.05% and as high as 2.95%. That's a 59-to-1 ratio. And so on that hypothetical $50 million in credit card sales that went away, the fee avoided could have been low as $25,000, or it could have been as high as $1.475 million. That's 2.95 times 50 million on the big end, and that's 0.05% times 50 million on the low end. And because Vizant didn't do any discovery, because it was made a conscious decision to go for the whole hog, let's try to get all this, instead of doing what they were obligated to do, there is no evidence about what credit card would have been used, which determines the discount rate largely, what credit card would have been used, what the discount rate would have been, and even if you took their position that we get 30% of all transaction costs avoided when you lost hundreds of millions of dollars in business, they haven't shown the transaction costs avoided.
But do they have to do that then if, assuming their position, that they get everything dollar for dollar that's saved anyway. Discount rate then would not apply.
Oh, no, the discount rate absolutely applies, because as I indicated, or at least tried to indicate before, not even Vizant takes the position that they get a percentage of your sales drop, the volume of sales drop. It's only a percentage of cost savings, of transaction costs avoided. And you cannot figure out the transaction cost avoided without knowing the discount rate. When I went to that store...
For purposes of getting past a summary judgment motion, under Kansas law as you understand it, how precise does your damage estimate need to be? It seemed to me that from reading your respective briefs that we were talking about a reasonable approximation or some language like that. Why is this discount rate discussion necessary given the requirement that there only be a reasonable approximation or something like a reasonable approximation?
Well, because I submit that a ratio of 59-1 and what the difference in the numbers could be isn't a reasonable approximation of anything. And Vizant can offer nothing more than it could be anywhere within this 59-1 ratio. It could be $25,000 on $50 million in sales lost, or it could be $1.475 million. That, I think, under any workable standard is not a reasonable approximation. They have to show damages to a reasonable certainty. Kansas law is just like North Carolina law on this. They have to show damages to a reasonable certainty. They have to give the jury a reasonable basis for computing damages. There is no reasonable basis to conclude that on that hypothetical $50 million in sales lost, that the discount rate would have been on the high end, 2.95, versus it would have been on the low end. And the difference is $1.42 million, $1.47 million in difference.
In your hypothetical.
In my hypothetical, of course, right? But again, because Vizant didn't do anything to do its homework, because of a strategic decision that it made to try to go get it all, which is precisely why they're in the box now of having to argue that they abandoned the position they took in the first two-thirds of the litigation, where they said over and over, and I've got it quoted in our brief at pages 17 to 18, we said over and over and over they had conceded that the contract required them to show as a result of, or they couldn't recover. But they had to abandon that because their strategy of not doing their homework and going for the whole hog backfired when Judge Bledsoe said, you can't do that. You have to show as a result of. So now, instead of sticking to what they started with, they have to try to convince you that under this contract, you ignore, as I think Justice Irvin, you said, am I supposed to just ignore the as a result of language, pretend it doesn't exist? That's what they're asking you to do.
I want to ask you about the implications of the as a result of language, given what happened in this case, because as I understand it, the contract on its face doesn't require your client to adopt any of their recommendations, right?
Right.
And as it actually happened, once they presented their report, your clients rejected it and didn't implement anything that specifically that they had recommended. So how could they show that any of your transaction costs, financial costs, were a result of anything they recommended?
If one were to interpret the contract to allow Vizant to get a percentage of cost savings realized as a result of their recommendations, even if we already knew them, YRC already knew them and was already doing them on their own, which is in fact the case here, then under that interpretation, which I think is way outside of what's reasonable, but Judge Bledsoe disagreed and said the jury gets to decide that part of it, right? Then that would be a way that they could claim a fee on things that we were already doing. But I want to take us back to where, Justice Irvin, I was answering your question and I got called away, and we were talking about how they reference paragraph 8 and paragraph 24 as being the solution to their problem. that they now have to try to make the contract say something different than they said all along it was. And I had mentioned how those two paragraphs both reference the term financial payment cost reductions, which is the key part of the definition that has the word as a result of. But those paragraphs do more than that as well. Paragraph 8 specifically indicates that financial payment cost reductions is all of the reduced or recouped or recovered costs, quote, provided they have been identified and recommended by Vizant. Vizant did not identify and recommend to YRC that a good way to save on transaction costs was to go lose a whole bunch of business, right? It has to be identified and recommended by Vizant, by the very paragraph they cite to. And paragraph 24 says the very same thing. YRC is not required to pay for reductions not identified as part of Vizant's professional services. Again, not trying to beat a dead horse, but Vizant certainly didn't say, if you want to save transaction costs, go lose business and you do less transactions. And I also refer the court to paragraph 2 of the contract, where it lays out what is Vizant going to do? What is it going to do to earn its fee? And paragraph 2 specifically states that Vizant will identify strategies that will result in savings. So when the entire description of Vizant's obligation under the contract, paragraph 2, says what you're going to do is identify measures that will result in savings, and you've got paragraph 6 that uses the as a result of language, and you've got paragraph 8 and you've got paragraph 24, which all say we don't get a fee if they didn't identify it. For Vizant to come in and claim that all of that language ought to be disregarded because one of our obligations was to give them a whole mess of financial data so they could sift through and try to find out where cost savings might have occurred, is an argument that I submit the court ought to reject. So
let me get you to comment, if you would, on the courts having granted the motion to strike the expert.
Yes.
I asked opposing counsel about that, and her response is, well, he can still testify with regard to a formula. It's just the specifics of damages that he was going to testify to that he couldn't. How do you read the consequence of that? Clearly, you followed up with a second motion before the trial court, which the trial court then granted. What is the practical result of the expert testimony that was eliminated having been eliminated?
The expert, his name is Scott Emanuel, and the only thing he was put forward to do was to say, here's the amount of damages. He was stricken in toto, which left Vizant with nothing that it could use to try to show a reasonable basis for calculating damages on the switch to ACH recommendation. So the effect of it was to allow, effect of the striking of the expert was to allow me to carry my initial burden on summary judgment of showing they could not prove an essential element of their claim.
Does that motion, having been granted, impact at all the second claim that's before the trial court?
No, I didn't even. The second claim was a recommendation that we charge some sort of fee for people who pay by credit card. As an aside, we already started it a month before they made the recommendation, but it was a $5 fee that was charged, and we produced records saying here's how many $5 fees we've collected. Even I can do the math on that, so I didn't move on the expert. So it doesn't affect that.
So is that the only issue that would remain if it goes back for trial?
The $5 fee? Right. Yeah, exactly. If it goes back for trial, if you say we're not hearing this appeal, it goes back for trial on the $5 fee. If you affirm, it goes back for trial on the $5 fee. If you reverse, it goes back for trial on ACH and $5 fee.
Wasn't there also a claim for declaratory judgment and injunctive relief?
There was.
And is that still left to be tried in the trial court?
It appears to me, based on statements made in pretrial conferences, that those claims have been abandoned.
Okay.
Thank you, Your Honors.
I wanted to start, Justice Hudson, by addressing, as Mr. Strauss mentioned, kind of an unusual situation where the appellant and the appellee actually agree on something, and that is that the issue that would be presented to a jury at trial, the first issue would read, was there a breach of contract? And that is where we would be at risk of getting different verdicts without a real understanding of what the reasons were why the jury may have had a different opinion on the interpretation of the contract. And there's so many provisions in the contract that to think of a way to do special interrogatories would really be unworkable, I think, in a trial situation. So I do agree with Mr. Strauss on that point. I do want to say that that Scott Emanuel, who was an employee of Vizant, we presented to show how the formula is applied to the data that is provided by the clients under these contracts. He did not just get hired to offer an opinion in this case. We still believe that Mr. Emanuel or some other employee of Vizant would be allowed to explain to a jury how the formula works. It's simple, well, it's not simple to me, it's simple to some people, but it's a mathematical formula. That's not giving an opinion, and I believe that they should be allowed to do that should the case be remanded for trial. And I think that there was a fundamental misunderstanding by Judge Bledsoe when he made his decision about the admissibility of that evidence because he evaluated it from an evidentiary perspective instead of interpreting the contract. The law requires us to provide a reasonable basis from which a jury could calculate the damages. That reasonable basis is what is contained within our contract, and we do believe that we can do that. And
Can you respond to Mr. Stroud's argument that Vizant's litigation position changed over the course of the case regarding the meaning of as a result?
I don't think that our position has changed at all throughout the course of the case. The as a result of language appears within the contract. There's no question about that. We can't deny that that language is present and ignore it, and we're certainly not asking any of you to ignore the existence of that language in the contract. What we're asking is for the court to do what black letter law requires, and that is to read the contract as a whole and not to isolate a specific term. And when we do that, we do not believe that the contract requires a showing, a specific showing, that as a result of means that we have to prove causation in order to get our fee. And, Mr. Stroud got up here and argued that, we should have had to identify something new. He didn't really want to get into it, but then argued that, we already knew how to do all of this. I have consistently said from the beginning of this case, I have always struggled with maintaining my weight. I know how to lose weight. Everybody knows how to lose weight. Fewer calories in, more calories out. And yet people hire consultants and pay them a lot of money every day to help them implement that formula. And I think one of the things that has gotten lost in this case is the application of this contract if the contract had continued to move forward. And it would have allowed Vizant to continue to work with YRC on strategies to implement these cost-saving measures in a way that they had not thus far been successful at doing. We evaluated their data in the year preceding the contract being signed between these two parties. It did not show a substantial change in credit card usage or ACH usage.
So with regard to the third-party discovery that Mr. Stroud mentioned as something that could have been done, is your argument that it wasn't feasible to do it or that it wasn't necessary based on the way the contract's worded in light of your overall argument?
Both, Your Honor. Both. It is not feasible to do given the number of customers that YRC has. And if I came up with, went and talked with 3 of them, they'd say, okay, well, that's 3. What about the other, 30,000 that paid by credit card that particular year? You're talking about a company that's collecting $900 million a year in credit card payments, and they are a less than truckload carrier, which means they have multiple customers in each and every truck that they have on the road. So it wouldn't have been feasible. We still would have had the same argument from YRC, and that is not how the contract was contemplated to work. We would not have been required to do that in order to get paid our fee had the contract moved forward as written.
Well, the contract, counsel appointed us to paragraph 2, which says that Vizant will identify, indicate, and quantify specific and actionable strategies and solutions that will collectively result in the reduction, elimination, and recapturing of the client's financial payment costs. So if that's required under the contract to identify and quantify all along what those savings are, why would it be hard to prove that at the time of the trial if that's been ongoing under the contract?
And that's our point, Justice Hudson, is we did that with the data that they provided under the terms of the contract. The data that we evaluated to assess where they could save money is the exact same data that we would use to calculate our fee from.
Thank you, Ms. Lincoln.
Thank you, Your Honor.
Thank you, Mr. Stroud, and to all counsel. Thank you all so much for being here today, and thank you all for being here to observe oral arguments, the first one for today. Madam Clerk, would you recess us for court?
All right. Oh, yes, oh, yes, oh, yes. Supreme Court of North Carolina will be in recess for 30 minutes. God save the state and this honorable court.